What's up, everybody? Appreciate you being here. Wanted to let you know before we get into the show, there's a couple of easy ways that you can help me with it. With ideas, problems, solutions to whatever you find interesting, anything from a word to an essay, just send it to me. Through the comment section, wherever you listen, on Instagram or Twitter, I'm on both at The Best Idea, or straight to the email, bestideapodcast@gmail.com. Or you can support it in other ways. You can rate it wherever you listen it to. That's probably the easiest. Subscribing to the YouTube page is very helpful. The most direct way is Patreon. Patreon.com/thebestidea. $1 a month just to show some support. If you do $3 a month, you'll get early access to the Stop the Presses episodes. You sign up once, you don't have to think about it again. I really appreciate your time. And here we go. Welcome back, everybody. Best Idea Podcast. I'm Stephen Cochran, and I would like to take this opportunity to lay blame, something that we like to do here. Take this opportunity to lay blame for our current situation squarely on your shoulders. I'm laying it at your feet, on your doorstep. For starters, so this was a case that dreams were rested on. Everyone knew the name, Roe versus Wade. You could just say Roe. People would know what you were talking about. But what do you know? What do we know about the actual case? What are these hopes pinned to? We have all this passion wrapped up in this singular case in front of the Supreme Court. 9 people. You'd think that the oral arguments would be quoted like movies by now. This was 1973 that this case was decided. I mean, let me ask you something. Who the fuck is Roe? Any ideas? No? How about Wade? Do you recall anything about Wade? Henry Wade was a lawyer, the district attorney in Texas. He was all set to go in 1963 to put Lee Harvey Oswald on trial for murdering the president, you might recall. Very liberal Democrat named Jacob Rubenstein, also known as Jack Ruby, put an end to that job when he shot Oswald in Texas. Again, a lot of killing going on in Texas in the 60s, tough times. Well, Mr. Wade then went on to try Ruby for killing Oswald in his district in Texas. A much lighter load considering Ruby shot Oswald with cameras running in front of witnesses and a lot of cops, whereas obviously Lee Harvey Oswald was a patsy set up by the CIA, FBI, Mafia, and Vice President Johnson to take the fall for a murder they didn't commit, obviously. So in 1964, Wade manages to put Jack Ruby behind bars for murder with malice, and that last part counts because Ruby's lawyers were trying to prove that he was legally insane when he shot Oswald. Turns out Ruby's mom had a touch of the schizo, and but it only took 3 hours for a jury to come out and decide they didn't buy it for Ruby. They thought he was sane and he killed Oswald on purpose with malice. So there you have him. You have Henry Manasco Wade in his 50s, feeling at the top of his game. I mean, what was in the news more than JFK being shot at the time? Nothing is the answer, and Mr. Wade had just put away his alleged killer's killer. So just, peak of the career right now. He's having a good time. And he runs squarely into the force of nature that was Norma. Norma Nelson McCorvey from Louisiana. We know her as Roe, Jane Roe. Her lawyers gave her the name to protect her identity at the time. From Louisiana, moved to Houston with her mom when her dad bailed out. Turns out, on more laws than just restricting abortions, Norma and the law did not get along. From Jump Street, she was having issues. She worked at a gas station when she was really young. When she was 10 is what I found. It's Texas. She stole some cash from the register and took off to Oklahoma with her girlfriend when she was like 11 years old. So the pair were laying low in a motel, Norma and the girlfriend. And apparently they were making out, and a maid walked in, unannounced, how rude, and saw these two girls kissing. And so this is Texas in the 60s. And they're lucky they weren't getting hung, but the maid snitched, obviously going to turn state's evidence in Texas. And Norma had to go to a Catholic boarding school for a while, around 12 years old. There's a lot of different writings about this woman. I read a few biographies about her, and there's some discrepancy, but the best I could come up with was about 11. And she had to go to this Catholic boarding school. And you will never, ever, 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 ever guess what happened to this child in a Catholic boarding school. I give you 3 guesses. Come on, be creative. You got it. She was molested, but not by a priest, by a nun. A nun. I know. You thought it was a priest. I thought it was a nun. A nun got this one. So after she leaves there, she spends some time in some state schools until she aged out, actually. Ended up living with a friend of her mom. And she's like 15 at this time, who she accused of raping her. And then only after that, her mom took her in. Very complicated, strange family situation. Clearly less than needed parenting. Why didn't the mom just take her in? I don't have the details. Most of these people couldn't be reached for interview. Long story short, she gets to be about 16 years old, and she meets her first husband, Woody. First child came with her first husband, actually. Woody McCorvey is where she got the name. She was born Norma Nelson. So McCorvey's like kind of a step up, I guess. Norma Nelson. But she was 16 at the time, married, pregnant. You'd be surprised if you traverse the legal landscape for age of consent. There's a lot of states that have a lot of exceptions where you might have like a 19-year-old legally having sex with a 15-year-old. I'll attach the list in the show notes. But anyway, she's pregnant, 16, in Texas. And, is this it? Is this the famous pregnancy that landed in court? 16-year-old, pregnant, first husband, wanted to have an abortion. No, that marriage did not last, shockingly. And she gave her mother custody of that child. So this is a child having children. She's had a rough start to life, and it's not going well. Then it turns out, after this, Norma's gay, as was betrayed by the motel scene. So after her mom takes custody of the baby, she gets a girlfriend, starts having steady work, and in true Norma style, boom, self-inflicted wound. Cheats on the girlfriend with a guy, baby number 2. Well, now the drinks are a-pouring, and the acid is being ingested. She goes hard in the paint on alcohol and acid. Gives baby number 2 up for adoption. This is our champion. She's been through it. So baby number 2 is also not the famously aborted fetus. And then, boom, back to back, pregnant again, 1969. And was this one through in vitro with the woman of her dreams? Negatory, just a pal that she hooked up with. Actually, for a long time, she claimed that she was raped by this guy publicly. But then she later admitted that it wasn't true, that she made it up. And if you noticed a little bit of flippancy when I was talking about her past earlier, when I found this out, that she claimed publicly to a lot of people that she was raped to have this baby number 3, but then later admitted that she made it up, it really makes me question the accusation that she had made earlier in her life. Because you just, now you never know. But this one is proven. She admitted that she had made this up. She just isn't as much a lesbian as her girlfriends would like her to be. So child number 3. Well, what is a lady to do? She decided she had enough with the adoption scene, wanted to end this pregnancy before it started. So she started looking for ways to have an abortion. You can't do it in Texas. It's restricted. So what do you do in this situation? Well, she sued the local district attorney, Henry Wade. But Wade hadn't done anything yet, technically, to be sued. They had laws in Texas that would be used against her if she went to get an abortion. So what she did was sued him because he was the DA. The district attorney is the office that would prosecute her if she tried to get the abortion. So she wanted to get out in front, or her lawyers wanted her to get out in front of it. What really was happening was these two attorneys had been kind of plotting to bring this lawsuit. They were looking for just a plaintiff, just the right plaintiff. They actually went shopping for a plaintiff. Apparently that's what they call it. And so this is who they decided to go with. What she wanted was 2 things. She wanted what's called a declaratory judgment, and she wanted an injunction. Okay, declaratory judgment, she wanted the court to say out loud that this law was unconstitutional and then stop Henry from coming after her using said unconstitutional law. Her lawyers were, one's name was Linda Coffey, really ambitious, had some experience, in her 20s when this came out. She got the second highest bar exam score in Texas when she took it, so she's definitely very smart, very capable, very young. And her partner, Sarah Weddington, who herself had to go to Mexico to get an abortion before this, they are the ones that sued Henry on Norma's behalf. They said that the abortion should be allowed because, so this is the important part. Why did they win? What argument did they use to win? Now, maybe you're somebody that it wouldn't matter what the argument is, as long as you get the right decision, you're happy. But if the argument they make isn't really strong, well, then the decision doesn't have to stick. So what did they actually say? They called it a matter of privacy. They said that abortion should be allowed because it's a matter of privacy. That was the argument, basically. Now, the right of privacy is not spelled out in the Constitution, okay? It's inferred, it's taken from the 14th Amendment, from the wording. They're reading between the lines when they talk about this right to privacy. So the 14th Amendment, what it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So if you have ever heard of the due process clause or equal protection, this is where they get that from. But you notice in there, it doesn't say anything about privacy. That is a right that's been assumed. It's an unwritten right. It's not explicit in the Constitution. Well, that's what they went with. And they won. Not only did they win, they won in the first court that they went to. It's not just the Supreme Court that agreed with them. The first court, 3 judges in Texas, agreed with them. Henry's office appealed, and then he won. And then it was appealed again to the Supreme Court. The court didn't even know if it had the ability to rule on the case. They were actually going to hear it just to see if they had jurisdiction. But the lawyers for Roe were really prepared, and they just went in. They said jurisdiction is not a problem, wiped it off. Here's all the constitutional problems with prohibiting abortion. And they rattled them off. And the one that ended up sticking for them was this right to privacy. On the flip side, the prosecution, Henry's office, appointed some frat boy douchebag called Jay Floyd. Perfect 2-syllable fucking name for an idiot. His opening is kind of a quote. I guess that's known. I'd never heard of it before, but apparently it's popular amongst attorneys. He said, this was his opening line. Mr. Chief Justice, and may it please the court. It's an old joke, but when a woman argues against two beautiful ladies like this, they're going to have the last word. It's like make you want to fucking puke in your soup. So he argued the case. Now, granted, he probably found, some willing people on this 9-white guy, 70-plus-year-old court to laugh at his stupid fucking jokes. Like, if you read a book by Bob Woodward about the Supreme Court, you'd be surprised how much laughter actually took place during these oral arguments, the opening statements and the question and answer period for each side. Just trying to figure out when a fetus becomes a person is just, hilarious. And then actually, once the opinion was assigned to one of the judges, they wanted to hear it argued again. So that happened. So it was actually argued twice. And that was really just to refine the opinion, but they did hear it argued twice. And at this point, we're in 1973. It was filed in 1970, 71. If you're curious, Norma had that baby. It was all tied up in court. She couldn't ever get the abortion that she was seeking. But it was for the better because she had a very deep change of heart, raised her daughter, named her Shelley Lynn, went on to become a serious Catholic anti-abortion activist until her dying day. I'm joking. She gave Shelley up for adoption too. But her name is Shelley, though. And Norma did become a Catholic crusader against abortion because consistency is her thing. She was even part of a lawsuit to reinstate abortion restrictions. Just kind of went with the wind, did Norma. And then, of course, on her deathbed, I shit you not, takes it all back. Takes it all back, says she was paid to do all of it by anti-abortion groups. So we will take Norma's word on things with a grain of salt. Which, by the way, I learned that probably comes from an old philosopher that had an antidote to some type of poison, and the main ingredient in the antidote was salt. So take it with a grain of salt, meaning be skeptical about unproven claims. Take the poison only with the antidote, sort of thing. In case you were ever curious where that grain of salt thing came from. Anyway, so what was Norma's contribution to all this other than getting pregnant for a third time? She signed the paper. That's what her lawyer said. Once Norma caught Catholicism, she was against abortions, and obviously the two lawyers that defended her were not. And they asked Weddington about Norma's conversion, and she said all Jane Roe ever did was sign a 1-page legal affidavit. So she signed a paper and was like hands off for the whole thing. She was just a means to an end. Anyway, so the case was argued again, and this actually might be surprising, but it wasn't a close decision. What we just had that just came down was a 5-4, right? It doesn't get any closer. Out of the 9 old white men in 1973 on this court, 7 of them agreed with Roe. 7 of the 9 agreed with their arguments. They said this part matters. This was the actual decision. The other question is, what was actually decided? Because it was not that all abortions can happen anytime at all. That's not what happened. What they said was, in the first trimester, the state cannot prevent a woman from ending a pregnancy. Okay, first trimester. You look at a fetus in the first trimester, barely looks human. What they're trying to figure out is, where is the line that you have to start thinking of a fetus as old enough, or not old enough, but along far enough to being a viable person. Where is that line actually? So what they said was, first trimester, the state cannot prevent a woman from ending her pregnancy. Boom. The state, society has no interest in a fetus in the first trimester. That's what they said. After that, if the pregnancy produces a child without harming the mother, which is not a guarantee, by the way. It's an important aspect of this debate. It's not a guarantee that a fetus will grow into a child without harming the mom. So once the child is able to live outside of the mother, the state now has an interest and can stop an abortion. That's not like a minute before it's born. That's weeks and weeks. You're talking mid-second trimester to third trimester. But you see how this is where it gets a little fishy, a little shady. And this is where a lot of religious lawmakers in different states stepped in to restrict as much as they possibly could after that first trimester. You saw, 15 weeks, 6 weeks, all that sort of stuff. But that's when the state has an interest and can stop an abortion. So like all rights, it was not absolute. And this was weaker than a lot of rights because it didn't actually have any paperwork. It is not explicitly in the Constitution. Obviously, abortion is not anywhere in the Constitution, but this right to privacy argument that they used is not word for word in there. And the health and life of the mother must always come first, was something else that they said. If she's in danger, the abortion cannot be restricted. That was their opinion. Pretty middle of the road. It's a compromise. It's a logic. You can follow the opinion. Now that opinion has changed. And so the question really is why was that ever enough for anyone? You can see that the people that disagreed with that opinion, with the original Roe versus Wade opinion, have been going at it since the day that decision came down. Over, I think, something like 200 lawsuits challenging Roe, different laws in every single state, constantly chipping away, trying to find the right legal arguments to get back to the Supreme Court, to get them to look at it in a different way, maybe with different people sitting on the court, get them to change their minds. Been going at it constantly. But specifically for people who believe growing people should not be a requirement because the condom broke or you missed taking a few birth control pills or just had sex the good old-fashioned way, to all people that think a person shouldn't have to put themselves at risk to grow another person, why was this opinion ever enough? This was at its best, 7 people saying that they thought this was a right. Not from explicitly from the Constitution, which is all they have to go on. The 7 people saying, we agree. I see what you're saying. It's obvious if it was in there explicitly in any sort of explicit way, then it would be much easier. But we get your argument. We agree, with 2 people saying that they didn't. But since the 70s, people that didn't want this to be a right, they've been fucking busy fighting in court, passing laws. So why was this ever enough? Because the real game in town is the laws. Is the fucking laws. This subject now should never have been in front of a judge again. Why? What is a judge for? Judges are there to read and understand laws, either the Constitution itself or laws that Congress has passed for the entire nation, or if it's a state court, laws that the states passed. We vote for the people that make the laws. It's the most important job in the government is making the laws. But the judges aren't there to make laws. And when Roe came down, there was no law for them to read other than these restrictions. Most important job in government is the people that make the laws, not the president, not the vice president, Supreme Court justice, Chief Justice, the whole fucking Supreme Court, the whole Department of Justice. All that falls behind Congress. Why? Because we decide who gets in. We hire them. We send them there. They pick who gets to be a judge. And if we're paying attention and we don't like the people that they're picking for judges, we can vote them out. This is exactly the sort of issue you need a law about. Not a single judge, not a 3-panel judge, not 9 Supreme Court justices, none of that shit. These people, judges, they give opinions. They give fucking opinions. They read, they listen, and they give their opinion. Opinions are cool and all. I'm sure these judges have really practiced giving their opinions a lot. But we cannot rely on that. So anybody, any of you, who have said some version of the following, or who have heard some version of the following and nodded along in agreement, who've thought it better to say nothing when in the presence of some version of the following nonsense of, my vote doesn't count. We get depressing, laughable numbers of people to vote in any election. It's like a sad joke. We get like half, maybe, in national elections, even less in local elections, because everybody's too fucking busy to adult for a day. You know, what else is going on that particular Tuesday that you can't stop by your local, public school and cast a ballot? Maybe spend like an hour or two a few days before that just doing a little bit of Googling, like step off Instagram for a hot second, don't TikTok for a few hours, and just figure out who, not just Republican, not Democrat, just the people, their names there. Don't worry about the fucking party affiliation. Just research the people, what they say that they're going to do, and chances are you might even be able to actually go meet these people, depending on which election you're in, and you give it, give it a little bit of your time. Give it a little bit of your time. An equally big problem to the ones who do go out and vote is they usually will let the mob do their thing for them. They just check a box next to either Republican or Democrat. I mean, imagine in the age of information that we're in right now, it's painfully easy to find out about people. Most of us do diddly fucking squat. Don't spend a moment on it. Oh, I'm a D, you're an R, I vote. Like, it's a pitiful, pitiful fucking way to be. So we've gotten what we deserve. And I don't care which side of this you fall on. If you're happy this opinion finally came down and that abortion's going to be outlawed in a lot of states, you had to wait pretty fucking long, didn't you? For this court case, and Republicans haven't really done much for you. If you're incensed that some states are allowed to make women grow people against their will, obviously now seems a simple law should have taken some priority before now. Yeah, Clinton could have done it. Obama could have done it. But they didn't want to. Or they just didn't. I don't give a shit if they wanted to or not. They didn't. It didn't happen. So here we are. Either we're going to learn from it and do different things in the future and grow up a little bit, all of us, or not. It would just be yelling into the vacancy. We'll see. I appreciate you listening. I'll see you next time.